Okay, great. All right, then I will begin. Well, thank you, everyone. We just had a very rousing and important panel discussion, our annual judicial panel discussion, always one of the most significant aspects of our program. We're very grateful to all of the members of the bench for taking their time to participate, and the other panelists, and also particular to Esther Lim, who is always the guiding force in helping to organize it. It is a tough act to follow, but if I had to pick a panel to follow it, it would be this one. This is our social justice, typically our social justice luncheon. And of course, we are all meeting virtually, so you can enjoy your lunch, if you would, while we are feeding our minds and our souls. Just as with other aspects of our society today, our lens of assessment and evaluation of intellectual property has currently turned increasingly towards questions of social justice. And naturally with that, the question of racial equity in connection with copyright is one of those sub-questions that comes sharply into focus. Increasingly, some legal scholars, for example, in particular, some critical race theory scholars, have, in connection with that issue, posited the question as to whether or not copyright is doctrinally or even fundamentally hostile to various forms of African American and other marginalized community creative output and creative endeavor. On the other hand, at the same time, other legal scholars and policy activists have advanced interesting arguments to suggest that copyright can be a powerful tool for socioeconomic empowerment of not only African Americans, but other marginalized communities. And so it is during this panel that we are going to have an opportunity to explore that issue and to address those questions. Needless to say, an hour will not be enough, so we will leave you thirsting and hungering for more, but we will cover as much as we possibly can. And to do that, we're going to dive in and we're going to ask ourselves, we're going to look for questions and data and answers to, is there evidence, for example, of conscious racial bias in the formation and implementation and execution of copyright law? Or at the same time, are there credible arguments of copyright as a powerful socioeconomic tool to advance the interest of African Americans and other marginalized members of society? So to take us through this intense journey, we have two absolute experts in all of these topics, all of these areas. With us today, we have Professor Robert Brauneis, who is a professor of law and the co-director of the Intellectual Property Program at the George Washington University School of Law. We also have with us Terica Carrington, who is the Vice President for Legal Policy and Copyright Counsel for the Copyright Alliance. And so we're going to divide the time roughly equally. We're going to begin with Bob Brauneis, and then we're going to follow with Terica Carrington, and then we're going to save just a few minutes for Q&A and open discussion, knowing full well, as I said, that this is a conversation that can go on and on. But with that, let's start and turn the mic and the camera over to you, Bob.
Well, thank you very much, Lateef, for that kind and generous introduction. And I'm thinking that I am opening my share tray here, and I am going to include system audio because we're going to be able to hear some things here. And I'd like to start my presentation. Are we seeing that? That doesn't seem to me as though we are. You're not seeing that presentation yet, are you? Okay, so open share tray, and I click on that, and it keeps popping out. That's strange. It was working perfectly well in the working perfectly well in the session in our green room. And now, when I try to do this, it bumps me right out of it. Well, let me just try one more time, because I, of course, put together these slides for this session, but I can do it without slides if necessary. But gosh, I'd love to get this audio in here. I don't know if anybody technically here can help me. I see it flash as if it's sharing for a moment, and then it pops out again. Are you seeing that flash?
Yes.
Yeah. And I don't know why it bumps me out. It bumps me right out after I bump in. Okay. Well, if anybody can help with this, that would be great. But the time is running, and we've got time to, I've got time to do what I got the time to do. So I will go ahead and proceed without slides and work through what I want to say. And I guess, the first thing I want to say is that I stand on the shoulders of giants, right? That there are wonderful people who have worked on these issues before me, and I'm inspired by them. So KJ Green, Funmi Herrera, Candace Hines, and others have all worked in this area. And inspired by them, I wanted to ask a very general question, but then, as it turns out, narrow down to a specific example. So the general question is, how could copyright law aid and abet racial discrimination, right? How could copyright law be racist by one definition or another? And one possibility is that copyright law could discriminate facially, right? Certain racial groups could be denied copyright, or they could be charged higher fees, or they could be disadvantaged in various ways. As far as I know, copyright has never facially discriminated on the basis of race. But of course, that's not the only way that copyright law could be racist, right? So the other way is that particular copyright law doctrines that, although they're neutral on their face, could disadvantage minorities, and I think could, in a stronger sense, foreseeably disadvantage minorities, right? I mean, disparate impact is one thing. Foreseeable disparate impact, where you know it's going to happen, is even stronger. So my two goals in this presentation are, first, to recover an example, right? So I want to argue that three related copyright doctrines crystallized in one case in 1950 called Supreme Records versus Decca Records, and that those related copyright doctrines foreseeably disadvantaged African-American recording artists throughout the 1950s and beyond. And then the second goal is just to consider what impact that should have on copyright policymaking. So the three doctrines are these. First, they're the refusal to protect musical arrangements for which federal copyright had not been obtained. And that later became codified as a federal statutory limit on the scope of protection of sound recordings. The second is the application of a very high, almost patent-like standard of originality to musical arrangements. And the third is the denial of copyright protection to unauthorized derivative works. So let me start just by studying the kind of historical and social stage. By the 1920s, music and recorded music was not being marketed to the general American undifferentiated population. It was being marketed to three specific segments. There were poor rural whites, and to them was marketed what was first called hillbilly music and then later became known as folk music. There were Blacks or African Americans, and to them was being marketed what was first called race records, but since then has had a number of successive titles: rhythm and blues, urban music, things like that. And then thirdly, for people who were neither on the kind of neither of the two out groups, the poor rural whites or the African Americans. There was popular music, right? And this was a little bit a matter of genre, but even more a matter of the race of the performer. And those two are really tied together, right? That if you were a Black performer, then your music was going to be marketed only to Black people, and probably it was going to be in some ways blues influenced. You were going to be channeled into that genre. So what happens in those circumstances to a particular kind of recording called the cover recording, right? So music publishers typically license songs to many different record companies. And as many of you know, the mechanical license in the 1909 Act confirmed that practice. So after the first recording, the music publisher was required to license to others making recording, hence the second and beyond recordings called covers, right? You were going to cover a song that was originally released by another artist, another recording artist.
Bob, if I can
yeah.
interrupt you for a second,
Yeah.
I don't know if you see it, but they've got your slides up.
Yeah, well, that's nice. Yeah. That'd be great. So I am, however, several slides. I'm about slide 8, I believe, at the moment. So if we want to wander through these slides, we are. Yeah, that's keep going. Yeah, we got to keep going. That's slide 6 and 7. So there's the different kinds of. Yep. All right. So here we are. So yeah, this is good. Okay. So stop right here, and we will proceed. And I guess I will give verbal cues about slide advancing. So we're talking about cover recordings, right? And in one person or this disadvantage were composers, right? So composers were disadvantaged because the license fee for cover recordings was set by statute in 1909 at 2 cents per record, and it was never adjusted for inflation over a 70-year period. So, by 1978, 2 cents is worth approximately 1/3 of a 1909 cent. That, of course, disadvantages African-American composers whose songs are being covered by others. And if you can click one further, I think you'll get to the last bullet point on this slide. But of course, that affected other composers as well. All composers, after a while, were undercompensated when covers of their songs were marketed. But if we go to the next slide, right, the more important thing, the one thing I want to focus on is not the composers, but the performers. And so if we go 3 bullet points forward here, just so that I don't have to keep going. Yeah, there we go. So, right, more commonly, those who arranged and recorded songs weren't the composers. They were recording artists, right? We would say performers, but really in more specialized sense, they were recording artists. And so in an original recording, African-American arrangers and recording artists would add lots of new creative elements to notated sheet music when they recorded the original version of a song, which was going to be released as the race record version of that song. And so that raised the question of whether a white recording artist could freely copy the elements created by those arrangers and performers and release a popular version of the song, which typically would have a much wider audience and would make a lot more money. This was litigated in 1950 in this test case called Supreme versus Decca Records, and we've moved to the next slide. We'll take a look at the sheet music, right? So here's the notated song. It is by an African-American composer, Harvey O. Brooks, who lived in Los Angeles and did a lot of film scoring, as well as writing songs to be performed and recorded. The first version of this song, the first recorded version of this song, if we go to the next slide, was produced by Paula Watson, who was a pianist and singer. And she and a number of musicians went ahead and created a recorded version of this song. If we move to the next slide, that version added lots of things to the notated sheet music, right? So where there's this hummed introduction and a repeating bass figure. There's an arrangement for various instruments: piano, guitar, bass, drums, 2 saxophones, hand claps. There's a male backup chorus that has new words to sing. So they compose new lyrics for the backup chorus to sing. If we move on to the next slides, so here's in red on the right-hand side the responses of the backup chorus to the lead singer, all written newly for this version. And actually, it's the next 3 slides that just show you, so you can keep moving through those slides. They just show you the various new lyrics that are being added for the male backup chorus to sing in this arrangement. Okay, so I think if we go to the next slide, what we're going to hear is about the first 30 seconds. If we click on that little speaker there, is that going to hear us, cause it to hear something? It does not, because I think when you shared screen, you did not click on share include system sound. So that's fine. If we can dispense with that for the time being. In any case, we can move on to the next slide. So when what happens next? Evelyn Knight, a recording artist for Decca Records, produces a cover version, and it copies just about everything that Paula Watson and her crew had added, right? The hummed introduction, the bass figure, the bridge, the backup chorus, the lyrics, they're all there. And so she's taken advantage of many, many things that Paula Watson created, not just the underlying song written by Harvey O. Brooks. And so if we move to the next slide, we'll see that Paula Watson's recording did very well. Next slide, please. Oh. Okay. So that's Evelyn Knight's version. Yeah, okay. We can move to the next one now, because without having heard Paula Watson's version, the hearing Evelyn Knight's version probably doesn't give you a sense of how close they are. So Paula Watson's version sold 250,000 copies. Nothing, right? It was a pretty popular song in the separate Billboard race records charts. It is sitting here at number 4, and it's in this chart, I think it's at its 12th week, so it's doing very well, right? But if we move to the next slide, we'll see that Evelyn Knight's version did much better, right? It goes up to number 1 on the popular music charts. It sells about 2 million copies, about 8 times the number of copies that Paula Watson's did. So if we move on, we will see that Supreme Records then was not happy about this and sued Decca Records. At the time, Paula Knight's editions are fixed only in a sound recording. There's no federal copyright protection for them. So this case is litigated under the banner of unfair competition law. However, the judge in the case, Judge Leon Yankovic, already had gained a reputation in copyright. In fact, many of you will know of a doctrine called laissez-faire. He invented that doctrine. He invented the term. And so he's writing an opinion that although it's not a model of clarity, it tries to make lots of copyright-like points. So if we move on to the next slide, right, we'll see that what does he conclude? Well, first, he concludes that elements that are in a sound recording and that are not protected in copyright as musical work can be freely imitated, right? And since protection requires notation, anything that's not notated, freely imitated. Next bullet point, he applies a very high standard of originality. And so here's some of the text from his opinion. Right, he says, well, the use of every one of these elements at this level of abstraction is well known in the art. No claim of originality can be based on their use singly or in combination. Well known in the art, that's probably familiar to those of you who come from a patent background. And indeed, this is a patent-like standard asking whether these elements somehow are a substantial advance over prior art. Now, I have to say, he combines with this high standard of originality, I think, a somewhat prejudiced aesthetic. So if we go to the next slide, right, he describes Paula Watson's recording as thick and mechanical and lacking inspiration. And by contrast, he says, well, Evelyn Knight's, that was rich and full and meaty and polished. So, of course, right, that Paula Watson's recording here really wasn't much of an advance. Further, and this gets, I think, quite pointedly to the racial aspect and the understanding of racial politics that it's quite clear that the court and the litigants are aware of. The Supreme Records objected to Decca introducing into evidence who each of the musicians were and their race. And the judge overrules the objection and says, no, you can go ahead and introduce evidence about the racial identities of each of the singer and all the musicians, because Decca argued, right, well, one of our defenses is going to be to show that Paula Knight's record was a race market record, and they had black musicians, and our record was a popular market record. And so we want to show you that these, the instrumentation on these records was different. Okay, move on slide-wise. So what's the immediate impact of this? Supreme Records declares bankruptcy. It liquidates. Next slide, please. And more broadly, the record industry takes this case to mean that any copying of creative elements on race records will be without consequence. And that starts a slew of white covers of African-American original recordings in the 1950s. And if we move to the next slide, please. All right, so lots and lots of these are released. I'm sure all members of the audience know of these examples by people like Elvis Presley and Bill Haley and the Beatles and the Rolling Stones and Eric Clapton. And if we go to the next slide, right, Little Richard, Tutti Frutti, sadly passed away last year, covered by Pat Boone. And Pat Boone's record does better than the original Little Richard recording in the same way that Evelyn Knight's does better than Paula Watson's. Next slide, please. And so nobody, no less a personage than Langston Hughes, probably better known today for his poetry, but writes a column in the Chicago Defender about this phenomenon. And if we click one more on that slide, I think we'll get to a quote from this column that he says, well, this is a compliment that white artists are making these covers. But why can't we get any kind of compensation or credit for this? If we could go to the next slide, please. So what happens in the meantime, right? What happens in the meantime? So in the early 1960s, when the Copyright Act of 1976 is starting to be drafted, the proposal is for a codification of the Supreme Records rule to limit the scope of protection of sound recordings. And that occurs completely traceable to this decision. Move on to the next slide, please. Right, and so Section 114B is currently, under the Copyright Act of 1976, the statement of that limitation comes directly from Supreme Records. Next slide, please. Right, secondly, there's a question of, under the 76 Act, well, how much can still be freely imitated through independent fixation? That depends upon what counts as a musical work. We know that until 1978, only elements fixed in visible musical notation count. And now, if you keep moving on the slide, right, fixation of musical works is possible in sound alone. Nonetheless, courts are somewhat reluctant to expand this. And so I've written kind of at length about this, and others have written about this, but there's still a sense that somehow the musical work is some narrower set of elements and doesn't expand to cover everything that's recorded in the performance of the work. Okay, so next slide, please. Right, what about a standard of originality? If we can keep moving on this, right? Some cases still apply a very high standard of originality. So if we move to the next slide, 1994 Woods versus Byrne Company, there have to be you know, something more than what's standard fare in the trade by a competent musician, right? That sounds a lot like faceta, a person having you know, ordinary skill in the art of performing. Cite Supreme Records, goes straight back to this case. Next slide, please. And then lastly, right, protection for derivative musical works. Both the 1909 and 1976 Act deny copyright to a derivative work that uses an underlying copyrighted work without permission of the owner. And that seems to allow a composer to grant rights to record a work and yet withhold the rights to any derivative musical work created. Next slide, please. That's sort of added on by the 115 mechanical license, which also says by default, when you produce a cover under the compulsory license, you're not going to get copyright for any arrangement that's created while you're making that cover. One slight silver lining to me is that I think there is some sense that more bargaining is taking place when, before original recordings are released, at least. And I'd love to do more work in this. Somebody looking for a paper topic and you're interested in empirical stuff, this would be a very interesting place to go. So the average number of composers credited on hit songs has increased a lot in the last 50 years, over double what it once was. I think that is probably some evidence that recording artists are being kind of melded into the composition and being given slices of the composition right, which I think is at least from this perspective, a plus. That is, that's a way within these constraints that performers are getting a piece of the composition pie. Okay, next slide, please. So, what conclusions should we draw? First, I think we should realize that the shape of copyright doctrines has played a role in racial discrimination. not necessarily facially, but here's an example of doctrines that seem perfectly neutral. And yet within the context in which they were formulated back in 1950, it was quite foreseeable that those particular doctrines were going to disadvantage minority and particularly Black recording artists. So I think about some modest suggestions and some bigger questions, and perhaps we should leave the bigger questions for question and answer, because due to the slide thing and so on, I think we're a little behind here. The modest suggestions, I think are just, let's when we're thinking about musical work copyright, let's think about adopting a sufficiently broad scope so that we're not tightening it down to melody and lyrics and allowing nothing else to count as part of the musical work. I think that we can see an example here. Justice Holmes in Blystein, some of you may remember, talked about the dangers of judges importing their own aesthetic sense into a case, and that's why the standard of creativity should be low. I think Supreme Records provides a prime example of a judge doing that, importing what I think turned out to be a racially prejudicial aesthetic sense, and was doing that in the context of having a high standard of originality. And then lastly, I think providing support for inclusiveness and authorship of musical works for purposes both of sharing the stream of royalties and for crediting, because I think the invisibility of minority contributions to our common culture, musical culture, is an issue, as well as, of course, their failure to be compensated for their contribution. So I'm going to end there, and maybe we can talk about some broader issues during Q&A. Thanks.
Excellent. Excellent. Well, thanks very much, Bob. I know that there are going to be a lot of interesting questions at the end. So for now, we'll keep it moving, and we're going to turn everything over to you, Tarika.
That would be great. Thanks. I also have a slide deck that I believe Elizabeth is going to load for me.
Yes, one moment.
Thank you very much. Great presentation, Bob. I learned a lot of really interesting information. Tough act to follow, but I'll give it my best shot. Okay, well, just to kind of save on our time while I'm waiting for the slides to get loaded up, I'll just go ahead and start talking. I think once you guys get the slides loaded up, you can probably jump to the slide that starts with copyright as a tool for marginalized communities. So just to kind of begin, I wanted to talk a little bit about what does it mean for a community to be marginalized? This is something that I was thinking about as I was preparing for the presentation today. And I think it quite literally means for communities, the needs, the perspectives, experiences of those communities to quite literally be pushed to the margins of society, as opposed to communities of privilege who have their needs, perspectives, and experiences centered. Those are the communities whose needs are catered to most often. And so, one of the things that I think is especially important, and one of the things that I love most about copyright, is the way in which it takes certain resources and options that are usually reserved for privileged communities and makes them more accessible to communities who are also in the margins, and in that way helps center the needs, the experiences, and the perspectives of marginalized communities. So I want to talk about 3 different ways that I see copyright doing this. And the first is what I'm going to call the privilege of property ownership. So as we all know, property ownership is hugely important to being able to be successful in this country, not only as an individual, but also generationally throughout, your family. There's a lot of talk about the racial wealth gap and what goes into the racial wealth gap, what keeps marginalized communities from being able to acquire wealth. There go my slides, perfect. From being able to acquire wealth has to do with certain laws and policies that have historically prevented property ownership amongst marginalized communities. Now, copyright does something that I think is a lot different. As Bob touched on in his presentation, copyright, the way that the law is written, we're supposed to have a low threshold for originality. And what that does is makes it so that no matter, how intricate or simple, no matter how much background experience you have, whether that's training in the arts, training in the music, or you are an amateur who comes and puts their work to paper without having had that formal education, that your work can also be protected. This is really important. And in copyright, the term of protection is life plus 70 years. So that means that you're able to not only benefit from your work during your lifetime, but also so that your heirs and your family generations going forward can also benefit from those. And that's a very privileged part of our society, property ownership, and the ability to actually earn from the works that you create. And then another point that I want to make about property ownership is that ownership gives control over how marginalized groups are represented. So we know about how important representation is in our society. There are studies that show that when certain communities don't have a lot of interaction with minorities or other marginalized groups, that they substitute the impressions and stereotypes that they see on television and in movies and books for reality. And so it's really important to be able to control how you and your community are represented. And then on the flip side, there are also studies that show that within marginalized communities, so for instance, the Black community, long-term exposure to representations that erase you or don't depict you can also decrease self-esteem. So that's one of the big things that comes along with the privilege of property ownership in this context. And the next, the privilege of exclusion. Marginalized communities are communities that are typically those that have been excluded from things. So whether that be physical spaces or opportunities or privileges. Copyright flips it on its head by giving property ownerships, copyright owners, the ability to choose who has access to those works and to be able to not be excluded, but to set the boundaries for how that work is, how people are able to be included or excluded from using those works in certain ways. And that's also really important because it gets at issues like authenticity and cultural misappropriation. When people come in and are able to use works in any kind of way that they want and perhaps don't understand the cultural implications and background that go into those works, that's how we get to issues like cultural misappropriation. And then, and third, I just want to touch on the privilege of voice and expression. So there's a lot of discussion, about giving a voice to the voiceless. And I think, although that statement is something that means well, marginalized communities aren't voiceless. It's not that they don't have voices, it's that their voices are not being centered, their voices are not being considered, they're not being heard. So one of the things that being able to create works of expression, being able to own those works and being able to dictate how those works are used actually helps to center these voices and perspectives. And so owning copyright in one's expression is a really important step in achieving that. Next slide. So some of the work that we do at the Copyright Alliance, we advocate for the interests and policies that benefit copyright from the creator perspective. So one of the things that we've worked hard on the last couple of years has been a big access to justice issue, and that is known as the Kstack. Next slide. So the Kstack stands for Copyright Alternative and Small Claims Enforcement Act of 2019. Next slide. And what this bill does, or actually at this point it's now a law, but what it does is create a small claims tribunal for certain copyright claims. So just before we jump into that, I want to give a little bit of background about what, why there's even a need for a small claims court. So as many people will know, federal courts have exclusive jurisdiction over copyright claims. One of the reasons why that is really important is because copyright is subject to a very extensive federal statute, and it's important that the law be applied as consistently as possible across the country. So it is really important that federal courts continue to have jurisdiction over copyright claims. However, at the same time, federal court is too expensive for most individual creators. There was a study done a few years ago by the American Intellectual Property Lawyers Association, which found that the average cost of litigating a copyright infringement claim in federal court from start to finish is close to $400,000. So your average person, your average individual creator is not going to be able to afford to actually enforce their rights. So essentially they have a right but no remedy. And when you think of numbers like hundreds of thousands of dollars, you're thinking of not even your average individual celebrity can afford that. You're talking corporate dollars at that point. So this is what I view as a big access to justice issue. Next slide. So overview, what the Kstack does is it establishes a small claims tribunal in the Copyright Office that's a voluntary alternative to federal court. It's for certain copyright claims, and it creates a cap on damages. So that's where the small claims part comes in. Next slide. So as I mentioned, this actually recently became law. It was signed into law on December 27th, 2020. The law will actually take effect, and the board will actually start being able to hear cases at the earliest December 2021 and at the latest June 2022. Next slide. So just a little bit of background about how the Kstack came to be. In 2011, the Copyright Office began a 2-year study on the need for a small claims court after the House Judiciary Committee Chairman Lamar Smith asked them to begin a study. He had heard some complaints from creators who were basically explaining, we have this right, but we actually can't enforce the right. So it's as if we don't truly have a right. In 2013, the Copyright Office published a very comprehensive study that involved, multiple open comment periods, hearings, and other things that went into them producing this study. And what was unique about this particular report is that not only did they recommend the creation of a small claims process, but they also took a step further and actually presented draft legislation, the bulk of which is actually encompassed in the Kstack today. So in 2016, the first iteration of the Kstack was introduced. There was a hearing held in 2018. Next slide, please. In 2019, a few things happened. The Kstack was introduced for the first time in both chambers. So previously it had only been introduced on the House side. This time it's introduced both in the House and the Senate. It went and passed through the Senate Judiciary Committee. It passed through the House Judiciary Committee. And then in September, Senator Wyden placed a hold on the bill along with another senator, Senator Paul. In October 2019, the House passed the Kstack 410-6, which is, if you follow any votes, that's unbelievable support for the Kstack. And at that time, also, Senator Paul lifted his hold, but Senator Wyden continued to have a hold on the bill. Next slide. All the way until the bill actually became law. So what happened was that in December 2020, congressional leaders started to realize that the Kstack was being held up not because it didn't have proper procedure, not because it didn't go through the necessary steps, but because one person's hold was basically preventing the bill from being passed, despite so much support for the bill. So it was actually, the Kstack was included in the year-end spending bill at the end of last year. And on December 27th, it was signed into law. Next slide. So some of the key components of the bill, as I mentioned previously, it's a voluntary process. It's a voluntary alternative to federal court. So that's one thing I really want to emphasize, because the Kstack, this small claims process, doesn't take the place of federal court. There are still people and organizations and companies who will choose to litigate their claims in federal court who can afford to do so. But for those who can't, or for those who it makes more sense to bring a case in small claims, this is a voluntary alternative to a federal court. And when I say voluntary, one important thing is it's voluntary, not just for the person or entity bringing the claim, but also for the defendant, so to speak. They have the ability to choose whether or not this is a forum that they would like to proceed in. And if they choose not to proceed, there are no penalties associated with that. Another important part of the Kstack is that it is a simplified and streamlined process. It's designed to allow creators and people to actually represent themselves before this tribunal. One of the big costs associated with federal court has to do with attorneys. It's very difficult to proceed pro se in federal court, especially with any kind of claim in federal court, and copyright is no different. So in making this process simplified and streamlined, it actually enables people to actually be able to represent themselves. And the bill also allows for pro bono assistance by law school clinics. So although they can proceed by themselves, they can actually get the assistance of people who have some experience in law and can actually help and assist them throughout that process. It's a totally virtual process. When a few years ago, that was, I guess, a more unique thing to think about. Today, everything is virtual. And so I have to say that has nothing to do with COVID. It was already that way. Most of the actual hearings would be, submitting paperwork. And if necessary to actually have a hearing, it would be done virtually, similar to how we're sitting here having this presentation today. And then importantly, this is a small claims process. And so statutory damages are limited to $15,000 per claim. And you want to think about that in comparison to federal court. So in federal court, it's up to $150,000 per claim. That's 10% of what you can get in federal court. And then in the small claims process, there's a cap of $30,000 total damages per case, compared to federal court, where there are no limits in what someone can recover in a federal claim. Next slide. So as I mentioned, not all claims are able to be heard in the small claims process. They specifically choose the kinds of claims that are more simple to litigate, more simple to hear, especially for an individual who's representing themselves to be able to, prove the factors and bring, the evidence. Part of the process being streamlined means that there's limited discovery here, and so that has to be taken into account when you're thinking about the kinds of claims that they can hear. So the permissible claims include copyright infringement, declaration of non-infringement, and DMCA 512F misrepresentation claims. So one thing that you'll notice about the kinds of claims that can be brought before the board are that these claims are those that apply not only to copyright owners or creators, but also to users of copyrighted works. So, if you are using a work and, someone accuses you of infringement and you believe that you have the right to use this work, whether because you have a license to use the work or because of fair use or some other exceptions in the law, a user could actually bring a declaration of non-infringement action before the board. Similarly, 512F misrepresentation claims, those kinds of claims actually go both ways. So those claims can be brought both by a copyright owner who says, a counter notice that was sent under the DMCA contained misrepresentation, so I want to bring that claim here. Alternatively, a user could say the same thing. A takedown notice that was sent under the DMCA contained misrepresentations, and I want to bring the claim here. And I think that's really important because not only is it expensive for a copyright owner or a creator to bring a case to federal court, it's equally as expensive for someone to defend against a claim like that. So this is a tribunal that will be effective both for copyright owners and for users. Next slide. And then another thing I wanted to highlight about this is there was a tremendous support for the bill, and the kind of support that you typically don't see together on one issue. So there was bipartisan support in both chambers. That's number one. But then if you look at this list of organizations, you typically don't see these organizations coming together and advocating for the same piece of legislation. And I think that speaks really heavily to the importance of this bill and what it actually does for people in society and making access to justice something that's true in copyright. Next slide. So some of the safeguards, because throughout the process of the Kstack, being introduced a few times and going through hearings, there was some, talk about, is this going to be abused? Is this system going to be something that will be able to abuse people who don't know what they're doing or don't know how to navigate the system? And there are actually a lot of safeguards in the bill. I'm going to highlight a few here, but number one is that, again, the process is voluntary. And so, there's sometimes discussions about potential for trolling, copyright trolling in a tribunal like this. And it's very hard to even conceptualize how that could be possible in a tribunal or forum that is completely voluntary. There's no real leverage that someone can exercise, because if you don't want to be here, you don't have to be here. You can opt out of the process. Additionally, the notice requirements for this process, although it is not an Article 3 court, the requirements for serving notice actually mirror the federal rules of civil procedure, plus some additional requirements through the Copyright Office as well. There are also penalties for bad faith claims or bad actors in the process. So if you are, shown to be bringing claims in bad faith, perhaps for a harassing purpose or some other inappropriate purpose, there are penalties, financial penalties that can be levied against you. You can also be prevented from even using the board for a certain amount of time. That's something that's not available in federal court. So that's one way that the small claim system actually has safeguards that go beyond what federal court does. And then another one is that the Copyright Office actually has the ability to limit the number of claims that can be brought. So for instance, if there is some kind of indication that the tribunal is being used in an abusive way by someone bringing, hundreds of claims, they can actually impose limitations to prevent that kind of thing. Again, something that does not exist in federal court. Next slide. So that is my presentation. I think I'm going to turn it over now. I think we have Q&A time.
Yes. Well, thank you, Terica. Again, another just excellent and informative presentation. I think that what I'm going to do is I'm going to try to sort of compress some of the questions, since we only have a few minutes. And one question that seems to be most prominent is that, so each of these presentations have demonstrated something really important. Your presentation, Terica, demonstrated to us the importance of grassroots and marginalized community participation in the construction and law and policy of these issues. Obviously, there were voices represented raising concerns about whether or not this right is really available, that helped to construct what this law was ultimately going to look like, and whether or not representatives, congresspersons and senators were going to get behind it. Bob, your presentation demonstrated something that is always very fascinating to me, and that is the importance and power of historical legal research. And it is something that I personally am just very fascinated by, because oftentimes we just look at the surface of the law. And the same way that we don't think about the issues that Terica demonstrated, we don't think about the law on the ground, right? We don't think about the grassroots aspects of it. What you demonstrated is that oftentimes we just look at the law facially. And the fact that, well, we don't see any facial evidence of either racial or gender or socioeconomic discrimination, we just take it for granted that there is none. And so here's the question, what we're left with, right? You each have demonstrated the ways in which the rules of copyrighted can be unfairly interpreted, implemented, and applied. On the other hand, you've also demonstrated how, but there is a way to utilize the system to be more effective for little copyright owners, for marginalized groups. So how do we reconcile this, right? I mean, obviously an easy way to reconcile these two possibilities is to say, you know what, it's just bad. I mean, it has a little bit of good. Let's just toss the whole system out and start from scratch, and then maybe keep some of the good things. But is it possible to reconcile it in a positive way? In other words, to say, you know what, how might we utilize copyright to do more of the types of things that you're striving for, Terica, and less of the types of deficiencies that you have highlighted for us, Bob?
Well, I'll take a stab at that question first. I think a lot of what we see today as far as marginalized communities being taken advantage of in the copyright context has less to do with the actual law and policy itself, and more so to do with how those laws and policies are being applied by individual actors. And so I think a lot of what can be done to help those communities is education. educating them on the rights that they have, how to exercise those rights, and making sure that when they come into these meetings, that they understand the rights that they automatically have. I mean, for one big thing is that a lot of creators don't understand that copyright is automatic. It's not something that you don't have to register your work. It's not like the patent office. You have those rights. And so you kind of come to the table with some degree of leverage just in being a property owner from the beginning. And so empowering them to understand the rights and know how to, look at a contract and say, this is not fair. This is, not typical practice, or, I believe that I can get a better deal elsewhere. I mean, I think the biggest answer that I have is truly just knowledge and understanding, and empowering creators in that way.
Wow.
Yeah, and I think my contribution is to say, yeah, Terika is right. By which I mean, even historically, there's probably no way to do this. But if you compared the the revenues that were lost by Black musicians and singers and the like because of the set of rules that I talked about, and the revenues that were lost simply because they were isolated and subordinated and could not negotiate in that condition for good contracts, and therefore lost many of their rights up front. I'd have to say it's probably the latter. It's probably the contractual stuff that contributed more to loss of economic rights and credit than any particular rule in copyright law. So I'm all in favor of what Terika is talking about, both education and things like the Kstack, which lower the barriers to dispute resolution when you need it.
Those observations, I think, are extraordinarily helpful for a number of reasons. And just to sort of summarize Terika, you're basically saying, yes, the way to get there is education. Bob, you're saying the way to get there is to have cognizance of certain systemic inequities, right? And to be aware of the fact that, hey, wait a minute, this is how it's actually going to play out. And I think that one of the reasons that these efforts towards a positive reconciliation is so helpful is because the basic reality is that I doubt copyright is going to go away, right? This is the mechanism that we have to work with. And I think perhaps, especially since we're about to run out of time, I would add a third consideration, and that is that not only would it help for those who are the subject of copyright to be better educated, for those who craft and implement copyright to be more socially cognizant that copyright is not implemented in a social vacuum, right? But then finally, also, I think the overarching lens to which we approach copyright. I mean, if we approach copyright as thinking about it as something that is, purely an economic engine to bring people to the table, and once people get up from the table, as long as a deal has been made, our work has been done. As long as you look at it only from that perspective, well, then you're not going to accomplish the things that each of you have suggested as a way to a positive reconciliation. And I think that if you think about copyright as performing a broader function, it allows you to consciously take into consideration the excellent points that each of you have raised, right? Because we won't always have you guys in the room. And so what we need copyright copyright law and policy makers, right, to walk away from a presentation like this and to understand that there is great hope and potential for the social justice effects and obligations of copyright, provided we have the good sense to come and to listen to people like Bob Brauneis and Terika Carrington, and then take that instruction and put it into actual practice. I think I know we're about 2 minutes over, but we have a lengthy break. Let me just see if there's any other questions that I haven't covered in the no, I think we're good. I think we're good. So with that, even though we've stolen 2 minutes of their break, they still get a lucky 13 minutes. I'd like to thank you both. Thank you, Professor Brauneis. Thank you, Vice President Carrington. Thank you both for this wonderful presentation. And with that, I suppose I will turn it back over to Tasha Bunch, who will probably just say to us, we can go on break now.
Thanks, Lateef.
Thanks, Lateef. This is great. Thank you for moderating.
Okay, thank you.
Thank you, everyone. We'll now be on a break until 3 p.m.